5, 4, 3, 2, 1. Before we proceed to consider the merits of the appeals, an objection taken to the maintainability of the appeals requires to be considered full stop. According to the respondents, the appellants in civil appeal have to locus standi either to object in the company court or to challenge the decision of the division bench of the High Court in appeal before this court full stop. It is submitted that those appellants are not creditors or debenture holders and they have nothing to do with the proposal and acceptance of the scheme under section 391 of the Companies Act read with sections 392 and 393 of the Act full stop para. This contention is sought to be met by the appellants in these appeals by pointing out that the appellant in civil appeal was associated with the original scheme for which approval was sought from the company court and that the appellant therein had in fact deposited a sum of rupees 18 crores as per the direction of the court and had also furnished a bank guarantee for rupees 10 crores and had allegedly discharged certain creditors of the company, and what was sought in the present case was a modification of the earlier scheme in which the appellant was involved, and in this situation the locus standi of the appellant could not be denied full stop para. It was also pointed out that there was a specific direction by the division bench to the appellant and others to present their schemes/proposals before the court, and they had filed affidavits in that behalf full stop. The company court was bound to consider their proposals in the light of the directions of the division bench full stop. The division bench in the present round also could not go back on what had been ordered by earlier division bench full stop. This gave the appellants sufficient locus standi full stop. The appellants in both the sets of appeals had also submitted proposals pursuant to the directions of the court and had also responded to the tenders issued as per the direction of the company court full stop. If the proceedings had continued in the company court, one of those persons could have benefited full stop. The benefit that was thus to accrue to one of the interveners was deprived of by the division bench by its present order, and in that situation, the appellants are persons who are aggrieved by the decision of the division bench and entitled to challenge the said decision in this court full stop para. It is also submitted that the framing of a scheme for revival of a company under liquidation had overtones of the public interest and commercial morality, and in the context of what had transpired in this case and the involvement of the interveners at every stage, it was not open to the respondent now to raise a contention that the appellants have no locus standi full stop. In fact, the division bench of the High Court was totally in error in excluding their objections on the ground that they had no locus standi, and as persons aggrieved by that finding, it is open to them to file these appeals full stop. इस वीडियो के डिस्क्रिप्शन बॉक्स में टेलीग्राम चैनल का लिंक दिया हुआ है जहां पे आपको ये पीडीएफ प्रोवाइड किया जाएगा.